Welcome to Canadian Justice. I'm Christine Van Gyn, and today we're discussing a recent court decision dismissing a legal challenge that had claimed Canada's voting system is unconstitutional. Canada uses a system often referred to as first past the post. In these systems, the winning candidate is simply the candidate with the most votes. The successful candidate doesn't need to win a majority, they just need to win more votes than anyone else. Like every electoral system, there are pros and cons of the first past the post system. And one of the most widely cited disadvantages is a sense that a vote for a losing candidate is wasted. And this is felt especially strongly by those who support parties that lack regionally or locally concentrated support, but may have higher levels of dispersed national support. Think of the NDP and Green parties' dispersed support compared to the regionally concentrated support of the Bloc Québécois. Those who have been hoping to change the voting system have argued recently in court that the first past the post system violates the Canadian Charter. Now, the Canadian Constitution Foundation, which is the charity I work for, intervened in this case to argue that while the system we've had since Confederation may not be perfect, it is perfectly constitutional. And we are thrilled that the court has agreed with us. Here today to discuss this are Christopher Kinsinger and Asher Honickman, who represented us in this case. Now, Chris, Asher, thank you both so much for joining us today, and congratulations on a tremendous outcome and for your exceptional advocacy in this case. Why don't we start with what the court held? What did they find, Chris, about the constitutionality of the first past the post system?
Well, Christine, Justice Morgan of the Ontario Superior Court made several findings regarding the applicant's charter challenge of the first past the post or single member plurality system. He rejected both of the arguments that the applicants had made that this system violates Section 3 of the Charter, which guarantees the right to vote, and Section 15 of the Charter, which guarantees the right to equality before and under the law. Beyond this, however, Christine, Justice Morgan made several key findings regarding the 1867 Constitution Act, which is what we focused our intervention on. And in effect, our argument was that because the 1867 Act manifestly envisions a first past the post system, even if it does not necessarily require such a system, this means that the system as the sort of default setting or status quo of the Constitution is constitutional and therefore can't be challenged under the Charter. And Justice Morgan made several findings to this effect in his reasons.
Now, I want to get to what they had argued. So the applicants who were challenging the system, Asher, they were arguing it violates Section 3 of the Charter, which guarantees voting rights, and Section 15. How did they say it violated these rights?
Well, if you take a look at Section 3, first of all, great to be here as always, Christine. And if you take a look at Section 3, the courts, on its face, it seems to guarantee a very simple right, just a right to vote. But the courts have interpreted that right very broadly over the years and basically said that it's not just a right to vote, it's a right to meaningfully participate in the election. And so the applicants were saying here, well, under the first past the post system, we cannot meaningfully participate. And essentially, as you were suggesting in your interview, people's votes are wasted, therefore our charter rights are being infringed. That there were other arguments, but that it seems to me was the principal argument they made.
And I mean, that seems to be stretching what courts have previously found about what the right to vote entails. Now, what about the Section 15 arguments, Asher? They had argued it violates equality rights or the voting system is somehow discriminatory. We've got about a minute. How are they making that argument?
Well, I mean, again, it's a very broad interpretation of what Section 15 protects. And again, it comes from case law where the Supreme Court has said Section 15 isn't just about laws that on their face discriminate. You need to really look behind the law and do a substantive analysis about what groups are suffering more than others under a particular legal regime. So in a sense, this case resulted from doctrine that the Supreme Court has handed down over the years that has really expanded upon what both of these rights entail. And the applicant seized upon that doctrine and said, well, because of this doctrine, we can say that actually first past the post violates the right to vote, and it also violates equality rights for certain groups who are discriminated against because of the first past the post system.
Now, it's obviously the court did not accept those arguments. And in fact, they cited with approval some of the arguments that the two of you had made in the factum that you submitted for the Canadian Constitution Foundation. When we come back from the break, I want to talk about that.